Well, good afternoon, everybody. Bill O'Leary coming to you from Legacy Planning Law Group, Thirsty Thursday, our series where I talk about different topics that might involve estate planning or elder law. If you're thirsting for knowledge, you come to the right place. Today's topic is why would you name a trust as a beneficiary of an IRA, a retirement account, whether it's an IRA, 401k, why would you name a trust? I'm going to just use the term IRA sort of as a generic reference, but it also includes 401ks, 403bs, TSBs, and the like. So they are retirement accounts that can pass to your loved ones when you die. So the question we get fairly often from parents is, is it better, let's say if we're naming the kids as the beneficiary of the IRA, is it better to name the kids outright in their own name? Or is it better to maybe name a trust for the benefit of the kids as a way to protect them? In a lot of situations, naming a trust is better. Look, trusts are terrific estate planning vehicles and tools that allow people to protect and preserve their wealth and to pass assets on to the next generation. IRAs, individual retirement accounts, but IRAs for short, are useful, again, vehicles that are often used to sort of grow assets free from income taxation now and to transfer those assets to the next generation. IRAs were introduced in the 1970s, and they become a very popular a structure or investment tool, if you will, for funding retirement, number one, and for accumulating wealth, number two. These sort of what are called tax advantaged accounts, there are tax advantages or benefits to them. Latest studies show that they hold collectively over $11 trillion in assets in this country. And so, frankly, that's more than a third of all retirement assets in the United States are held in IRAs. So, as the significance of IRAs has grown, it's become more and more common to name a trust as the IRA beneficiary. And what that does is it combines sort of the tax-advantaged growth of an IRA with the advantages that trusts historically have given us forever. So when a client, let's say a client comes to talk to us, or anybody, any account holder, they reach age 72 and they have to start taking money out of the IRA account, what are called required minimum distributions, RMDs, and they have to take them out each year. If we're talking about a traditional IRA, if we're talking about a Roth IRA, that's different. I'm focusing on traditional IRAs, and the RMDs are based on the age of the account owner and sort of their life expectancy under IRS tables. Now, given the way that the IRS tables are set up, if a client withdraws just the RMDs from their IRA and not any more, then there will be assets left over at the account owner's death. That's just the way the tables are set up. And if the IRA has a fairly good sort of investment rate of return, it's possible for that IRA to have even greater value at death than when the client started taking out the RMDs. So the IRA, with its sort of remaining assets, it does not pass under the client's will or their trust, but instead passes to whoever they have named in the IRA beneficiary form. The most common designations are to individuals, let's say all to a spouse, or maybe all to the kids in equal shares, or maybe the spouse is the primary beneficiary and the kids is what are called the backup or contingent beneficiaries. But you could also, instead of, let's say, naming the spouse or the kids, name a trust as the beneficiary of the IRA and just have then the kids as beneficiaries of the trust. And again, in many situations, naming a trust is better. So what are some of the reasons to name a trust as the beneficiary of an IRA? When a trust is named as the beneficiary of an IRA, what happens is the trust then inherits the IRA when the account owner dies. The IRA account is then maintained as a separate account that's an asset of the trust, you see. So here may be some good reasons that we have seen as to why someone might want to name a trust as an IRA beneficiary instead of an individual. Number one, sort of working around beneficiary ownership limitations. Maybe your intended beneficiary is a minor child, and legally they can't inherit the IRA. Or maybe the account owner has a special needs loved one they want to name as a beneficiary, of the IRA, but if that special needs individual then inherits the IRA, they will risk losing their government benefits. Or maybe the account owner wants to protect the IRA for the benefit of an adult child from the possibility that that adult child might get divorced or in maybe some sort of car accident lawsuit. A great solution to these problems is to name a trust as the beneficiary of the IRA, which again then becomes the legal owner of the account in place of the individual. Another reason, maybe sort of addressing a second marriage or other family structures. Maybe an IRA account owner might want, you know, those required minimum distributions, RMDs, to benefit his second spouse during that spouse's remaining lifetime, but then make sure that they'll at least have money still left in that account to pass to his own or her own children from the prior marriage. If the IRA owner leaves an IRA just outright to the spouse, well, certainly that surviving spouse will benefit from the IRA, but he or she, the first spouse, that I can't guarantee that their children will get anything at the end of the day. So if instead he leaves the IRA to a properly set up trust, then his or her desire to benefit both sets of beneficiaries, the surviving spouse, number one, and the second set, kids from the prior, then that wish can be carried out. Let's say limiting a beneficiary's access to the IRA money might be another reason to name a trust. You know, clients often think of IRA beneficiaries as just taking the required minimum distributions out. But a loved one who inherits an IRA, they have the ability, if they want to take out more, or even withdraw the entire balance of the IRA, and that happens fairly often. But on the other hand, let's say the access of a beneficiary to an inherited IRA that's owned by a trust, it's going to be restricted. You can restrict it to make sure they don't liquidate the entire account, which of course is generally a bad idea because then your loved one, the beneficiary, has a huge tax bill. What about the issue of naming successive beneficiaries? Well, when an individual IRA beneficiary inherits an IRA, they can name their own successor beneficiaries so that if they happen to die before they've taken all the money out of the inherited IRA, the successor beneficiary will step in. The IRA account owner, the original account owner, may want to control who the successor beneficiary is beyond the initial beneficiary, and if that's the case, the owner can use a trust to set up those succession terms. How about providing creditor protection? You know, a person's own IRA, the account owner's IRA, has protection from their creditors. Okay, the law is fairly clear on that. But that protection doesn't necessarily carry on to a loved one who inherits the IRA. The U.S. Supreme Court about 7 years ago or so came out with a ruling that inherited IRAs do not qualify under our federal bankruptcy code as being protected from the claims of creditors because they don't constitute retirement funds in the hands of the inherited beneficiary. It may be a retirement fund in the hands of the original account owner, but not in the hands of the beneficiary. So if the account owner wants to protect that inherited IRA for, let's say, the children from the children's possible creditors, using a trust is a great way to do that. So you know, an important issue with IRAs is how the money in the account comes out. So for the account owner, we've got RMDs that start at age 72 under current law, but there are also withdrawal rules that apply to the beneficiary who inherits the IRA. So for many years, the preferred payout method was what we call the stretch IRA, where the RMDs after the death of the original account owner could be stretched over the remaining life expectancy of the beneficiary, with those distributions usually occurring every year. So with that stretch IRA, as we used to call it, the account owner would continue, or the account itself would continue to grow tax deferred, I should say, often for many decades after the account owner's death. Well, a recent change in the law a couple years back called the Secure Act has significantly reduced the ability to use stretch IRAs. So that prior stretch rule now has been replaced, at least for most inherited beneficiaries, with a 10-year payout rule that requires the IRA to be distributed out to the inherited beneficiary by the end of the 10th year. We no longer have annual required distributions to the inherited beneficiary. They just have to take it out by the end of the 10th year, okay? So This 10-year rule, this new 10-year payout rule, applies to most beneficiaries. There are some groups of beneficiaries that can still use the stretch IRA. For example, a spouse, surviving spouse, the children, at least if they inherit it while they're still a minor, they can stretch it out. Certain people that are sort of meet the definition of somebody who's disabled or chronically ill, okay, under certain rules, and somebody who is not more than 10 years younger than the IRA owner. These types of beneficiaries are a special group called eligible designated beneficiaries. Again, as I said, they can continue to do the stretch IRA. So the post-death RMDs, though, for a trust that's named as an IRA beneficiary is going to be calculated based on either the stretch payout rule, the old stretch rule, or the 10-year rule, or even maybe a separate 5-year rule. Those generally are the three options. And it depends on certain things, okay? The type of trust that you have, if it's set up correctly, you're going to have the most benefits available to you. And also it depends on the nature of the trust beneficiary. So does the trust itself qualify as what we call a see-through trust? Is it set up correctly? Who are the beneficiaries? Are they human beings as opposed to a charity? A charity is going to cause a problem if the charity is a beneficiary of the trust. So again, these sort of different issues will dictate, whenever a trust is used as a beneficiary of an IRA, the payout rule that we're under. You know, the analysis of which RMD rule applies, which payout rule applies, isn't always clear. And so there are certain aspects of the Secure Act that we still need further clarification from the IRS. So for this reason, it's important to involve your estate planning attorney in any decision whether to use a trust as beneficiary of the IRA. You're going to want to confirm with your estate planning attorney the reasons for naming a trust. There has to be a good reason, and there are plenty of very good reasons to do that. Naming a trust as the IRA beneficiary. Make sure that the beneficiary designation wording has the right verbiage on it to refer to the trust. And you want to make sure that it's not going to be negated by the RMD payout rules, okay? And it's also very important to constantly review your beneficiary designations to make sure that any trust beneficiaries, that the proper verbiage is used. Sort of one final thought, you know, it's important that the RMD payout rules, they're different from the payout rules of the trust itself. So imagine you've got the IRA account up here, and you've got an individual child down here. In the middle is the trust. The IRA is paid out to the trust, but then the trust can be paid out to the beneficiaries. Well, the IRA inherited account and the trust don't necessarily have the same payout rules, okay? So even if an IRA has to be paid out by the end of the 10th year, or even the 5th year, and if it's going to a trust, it doesn't necessarily mean that those assets, once coming out of the IRA and into the trust, that they necessarily have to come back out to the trust beneficiaries by that 10th year. Instead, you look carefully at the terms of the trust. For example, if the trust is what we call a completely discretionary trust, then once the IRA assets are distributed out of the IRA to the trust itself, then the trust will tell us when and if that money has to be distributed back out to the beneficiaries. And there are ways to keep that money inside of the trust, again, to try to protect that beneficiary. Let's say they have certain things going on in their life. So again, very important that the payout rules that the sort of the IRS tax code gives us coming out of the IRA are different than the distribution rules in the trust itself. So a little technical, but a very, very important distinction. Again, talk to your estate planning attorney. So I hope you've enjoyed this talk. If you'd like to learn a little bit more about why you would want to name a trust as beneficiary of your IRA, and maybe you'd like to know about how maybe we can help you with that, go ahead and reach out and schedule a 15-minute free discovery phone call with us. You can do it on the Book Now page, a button on the Facebook page, or just give us a call, legacyplanninglawgroup.com. Just Google us. This discovery phone call sort of gives us a chance to start a conversation. You can tell us, sort of what your concern is. That way we can tell you if we can help you. And also we start to get a feel for whether we might be a good fit or not. Okay? So hey, if you've enjoyed this video, please like it, or better yet, share it. Again, just trying to get the word out. So I hope you've enjoyed this talk. Again, this talk, why would you name a trust as beneficiary of an IRA? I'm going to give another talk next Thursday about this time as part of our Thirsty Thursday series. So as I like to close by saying, if you're thirsting for knowledge, you've come to the right place, and we will certainly quench your thirst. So Bill O'Leary, go ahead and signing off for now. On behalf of everybody here at Team Legacy, go make it a great day.